the conclusion is the fact that you object, and you've indicated certain objection to techniques that may or may not have been proved legally by Mr. Haynes, but you keep citing the conditions. Where in any of these materials are there those conditions, as Mr. Mora refers to, that would give specific guidance? I don't think the Secretary of Defense signed a memorandum that talked about the conditions. Are you aware of those conditions that he approved?
Senator, the conditions were in several different contexts. In the Colonel Pfeiffer memo that came up, it specifically said that was attached to General Hill's memo. Colonel Pfeiffer's memo was the one that listed the techniques. And that one made it clear that the use of the techniques, at least the Category 3 techniques.
Well, the Pfeiffer memo said they were needed. Where is there a direction of the Secretary of Defense that these are mandatory as part of the use of these techniques?
The only thing in writing from the Secretary of Defense was his approval of Mr. Haynes's memo. As there were meetings leading up to the Secretary's approval of the memo, and the context of the conversation was, and of the discussions were one particular detainee, the particularly high-value detainee who had resisted. I mean, it was in the context of the discussions.
Thank you. Thank you, Mr. Chairman.
Senator McCaskill.
Let me start by saying how proud as an American I am of you, Mr. Mora. Courage comes in all forms, and you showed great courage. Let me cut to the chase here and see if we can reach some agreement. Ms. Dalton and Ms. Beaver, do you both believe that putting a group of detainees together, completely naked, hooded, and sicking dogs on them is legal under the UMCJ or anything else that our military should be paying attention to? Do you think that's legal?
Senator, I don't believe that's legal, and that was never approved by the Secretary of Defense.
Okay. Ms. Beaver, do you think that's legal?
No, ma'am, and it never occurred at Gitmo.
Okay. All right. Well, I'm reading this legal memo, and I'm reading the memo by Mr. Fife. Now, I got to tell you, you're both trained lawyers, correct?
Yes, ma'am.
And you both know that words matter a lot in the law. The difference of one word can make a huge impact on a legal analysis, and that's what you're trained as a lawyer to understand. Is that correct? Ms. Beaver?
Yes.
Yes.
Dalton?
Yes, Senator.
All right, I'm looking at this memo. It says removal of clothing under Category 2. And it says under Category 2, using detainee phobias such as fear of dogs. Now, I'm trying to figure out as a lawyer how removal of clothing and using fear of dogs does not envision naked people. By the way, the hood's in there too. Naked people having dogs sicked on them. How does that not occur to either of you, that might be envisioned?
Because, ma'am, in the discussions that the staff had, when you develop a plan, a professional plan of interrogation, there are limits and there are conditions and there's command approval. And if somebody said, let's sick the dogs on them, that would have never happened. I mean, that's just not professional. That indicates something.
But it did happen.
It did not happen, ma'am.
Well, dogs were used with naked people.
Dogs, well, in the context that you're saying it, I'm not aware that ever happened at Guantanamo Bay, Cuba.
I'm not talking about Guantanamo Bay. I'm talking about within our military. It happened.
My experience is Guantanamo Bay, Cuba, and so I can't comment on how it came to be.
Ms. Dalton, can you comment?
Iraq.
How it happened?
No, Senator. Those techniques that we're talking about were approved for Guantanamo Bay and Guantanamo Bay only. They did not involve nudity. They did not involve sicking,
you say it doesn't involve nudity. It says removal of...
The witness be allowed to finish her answer before the question comes again.
I apologize. Go ahead, Ms. Dalton.
Senator, as I was saying, the techniques approved by the Secretary did not involve nudity. They did not involve sicking, snarling dogs on detainees.
All right. Removal of clothing.
Well,
now, when you were discussing the safeguards, Ms. Dalton, in these discussions you had about safeguards, did anybody talk about putting in the word all? Not allowed? I mean, did anybody talk about that phrase, that removal of clothing? If I saw removal of clothing and I was trying to get information out of a detainee, there's nothing there that says removal of some clothing. It says removal of clothing. How would anyone know from that guidance that nudity was not allowed?
Senator, that was one of the specific questions that was addressed in discussions with Guantanamo, with General Miller, and with others concerning these techniques. I specifically recall that we had discussions about that particular issue, and the people I spoke with, and my recollection is that it was General Miller said it did not involve nudity.
Right. Well, it doesn't say that. There's nothing in this as a legal analysis, as a lawyer, that would tell you that nudity is prohibited. It says removal of clothing. It doesn't say removal of some clothing. It just says removal of clothing. So I don't understand how that is a safeguard. Let me ask you about this concept I talked about with the last panel, advance immunity. Are you aware of any concept in the law, Ms. Dalton, concerning immunity in advance?
I'm not.
And did you read that phrase in Lieutenant Colonel Beaver's legal opinion?
I did.
And did it jump out at you?
It was one of the, yes, Senator, it did. It was one of the issues in the legal memo that I thought was not accurate or correct.
Did it concern you that a legal opinion that people were relying on contained a concept that on its face would be illegal, which it would be to give somebody immunity in advance?
Senator, that's why that's my understanding of why both Colonel Beaver and General Hill asked for additional legal and policy review. That's why I believe that there needed to be additional legal and policy review at the Joint Chiefs or at the OSD General Counsel level.
Okay. Your opinion, and by the way, Lieutenant Colonel Beaver, I feel for you today. I think this is hard. And I think you're a good American, and I think that you were asked to do something, and I don't really understand how it happened. My job is to figure that out and try to make sure it never happens again. I'm reading from your legal memo where you say, I agree, you say the proposed strategies do not violate applicable federal law. Do you still stand by that opinion?
At the time I wrote that opinion, the law was such that I believed that the law allowed a lot. I'm not talking about policy. I'm talking about the law at that time, with the Geneva Conventions not applying. And if you would look at European Human Rights Court's opinion, when you mention hoods frequently, even the European Human Rights Courts would tell you that I'm not advocating anything. I'm telling you hoods are allowed in interrogation.
Okay.
So even in decisions by the European Human Rights Courts, which I looked at, for example, hooding by itself is allowed and is not cruel, and it also is not torture. So I tried to weigh all of these things, but I understood that I was at the bottom of the food chain, and that I might not have all the facts, and I might not be aware of all the issues. I didn't think of many of the things that I later saw in the opinion, the 50-page opinion written by the Department of Justice. So I was confident that if this got off the island, and then it went to a command that was in CONUS, like SOUTHCOM, where it could be looked at by people who were not directly involved in the interrogation of, in the instance of this HVD that we thought might have knowledge about another attack against the United States, that the right policy decision would be made. And on the military justice point, I did not artfully craft that section, and that's the only part of my opinion I regret, because I was trying to highlight my extreme concern for the military personnel under the command of Major General Miller, that if techniques weren't lawful, that military police personnel in particular could find themselves maybe be prosecuted later. And so I did not draft that very well, and I admit that. But for me, it was a red flag to people like Captain Dalton at the time to say, I'm very concerned about the military personnel. Please take a look at this. And unfortunately, Colonel Superville never responded, so I never got any feedback until the SecDef's opinion.
No, I get what happened here. You felt you were at the bottom and you needed to move it off the island, and somebody, I think you said in a calm and rational way, was going to look at it. The scary thing for me is that you put your name on it as the lawyer who was asked to give a legal opinion. And then, of course, everyone wanted to glob on your opinion, because why should they have to take the heat if you'd already done it for them? And here's what I want to, if I can, before I know my time's up, but let me just finish this point. You have said in your statement, you have said in interviews with the staff that you didn't feel pressure from anyone.
I did not, ma'am.
Okay. I'm trying to figure this out. You said in your memo, the proposed strategy does not violate applicable federal law, but the whole phrase is agree